Hello, hi, morning viewer. Welcome back to my channel, Hocantalk. Today in this video, I'm going to introduce to you a very important topic called Law of the Sea. Let's begin with the historical development. The concept of controlling the seas stretches back to ancient times. Early civilizations, such as the Greeks, the Roman, all viewed the sea largely as a highway for trade, but also as a contested space. By the Middle Ages, maritime cities like Venice and maritime republics established their own rules for navigation. However, a major shift occurred in the 17th century with the Dutch legal scholar Hugo Grotius, and he argued that the sea was a global commons open to all. If you look at the slide, the I actually put a picture of him at the middle of the first slide. And his idea challenged the notion of national control and laid down the foundation for modern principle of freedom of navigation. Now, fast forward to the 20th century, and we see the rise of international efforts to formalize all these rules about the sea. Now, after World War II, the need for global governance became very clear. And in 1958, the United Nations convened the first conference on the law of the sea, resulting in signing of four treaties among all the members' countries. However, it was the 1982 United Nations Convention on the Law of the Sea, known as UNCLOS, that became the most comprehensive and widely adopted framework. UNCLOS, if you look at the slide, which is the right hand side, I actually put down the picture to display the United Nations Convention that resulted in UNCLOS in the year 1982. UNCLOS often referred to as the Constitution of the Oceans, and this agreement defines the rights and responsibility of all the nations in their uses of the word oceans. Now, despite the fact that UNCLOS has been passed in the year 1982, but if you look at the second slide, I actually produce all the countries in the world that have yet to ratify UNCLOS, meaning the convention to regulate all the law of the sea. Those in red color are those countries that have yet to agree to recognize the law or are still waiting to ratify the law. Now, as of April 2024, 168 countries have ratified or acceded to UNCLOS, so making this widely adopted. However, there are still about 16 United Nations members or observer states that they have neither signed or ratified it. So there are still a lot of UN members country that are still debating about UNCLOS, especially the United States, Turkey, and a few others such as Andorra, Israel, Kazakhstan, and Venezuela. Now, if you look at the slide, you can see that on the right corner, USA has not ratified, or up to now, they are not willing to ratify the United Nations Convention on the Law of the Sea, in short called UNCLOS. So, as 2026, the United States remains the most notable non-party to this agreement. While the US played a leading role in the treaty's negotiation and recognizes most of its provision as customary international law. Now, why the US refuse or up to now do not want to ratify UNCLOS, especially when they are deeply and very much involved in the negotiation? Now, the primary reason for this is because of a part in the UNCLOS called the Part XI of the convention, which governs the management and exploration of minerals on the deep seabed beyond national jurisdiction. And in order to resolve this, in 1990, the United Nations Secretary General initiated a few consultations to modify Part XI and address the concerns of those industrial nations who refused to ratify the treaty. This led to the 1994 Agreement on Implementation, which effectively threw out the most contentious provisions. And despite these major concessions, which led many other developed nations like the UK and Japan to ratify the treaty, the US Senate has still not provided its advice and consent for ratification. Now let's move off on to some of the details of the law of the sea. If you look at the next slide, I actually put down all the zones specified by the UNCLOS, the treaty, the agreement, regarding which part of the sea belong to which country and what are the rights that this country have on the sea that's surrounding their country or their coastline. So here, there are different zoning of the ocean. And if you look at the slide, you can think that those who are considered the baseline case of the zoning is exactly like a dry land belong to the country that is next to the sea. Now, there are a few zonings, so I'm going to go through them one by one in details. Now, the starting point to calculate all these zonings is the baseline. And the baseline is the starting line. Usually, it is the low water line along the coast, which is marked on a large scale chart. So the one that is nearest to the shore is called the baseline. And the baseline, the state or the country has absolute sovereignty here, which is exactly treated like their own land. No one can go there or do anything in the baseline zone. Starting from the baseline, if you stretch out 12 nautical miles from the baseline, is called the territorial sea. Now, this sea, the country that next to this sea has 100% sovereignty. This is considered the sovereign territory of the country next to it. They own the water, the seabed, and the airspace above it. But there are exceptions. There are exceptions. This is called the innocent passage. Innocent passage. Now, foreign ships under UNCLOS have the right of innocent passage, meaning they can actually sail through this sea. They can transit through this water as long as they don't do any fishing, they don't do any spying or weapon testing or polluting the sea. But for submarine, when they go through this sea, the territorial sea, they must travel on the surface and show their flag. Now, looking at the slide, if we move another 12 nautical miles into the sea, you look at the lighter blue color zone, that is called the contiguous zone. Now, the contiguous zone is another additional 12 nautical mile beyond the territorial sea. So in all together, from the baseline is 24 nautical mile. And the purpose of this zone, this is called a buffered zone. The state or the country doesn't own this water, but it has the power to enforce laws related to four specific areas, which is customs, taxation, immigration, and pollution. So it is essentially a police perimeter to catch smuggler before they actually hit the shore. Now, after this contiguous zone, if you look at the slide, the green color zone called the exclusive economic zone is the third zone, which is stretches up to 200 nautical miles from the baseline. The country in this zone has sole exploration rights over all natural resources. This include fishing, any living resources, oil, gas, and mineral mining, non-living resources, or energy production from water and from the wind. So you can do windmill and wind farming here. But how about the rights of other country that is not the country that own this exactly exclusive economic zone? Now, the other country they have the freedom of overflight, meaning the plane can fly over this zone, and navigation ship can sail through this zone, and they can lay submarine cables or pipeline in this area. Now, anything beyond the exclusive economic zone is called the high sea. And this is the common heritage of mankind. Everyone can do all kind of activity in the high sea. Now, the next slide is actually a duplication of the previous slide, but I make it more informative to cover what I want to discuss later on in subsequent of this the video. Now, if you look at the left-hand side, I actually repeat what I've discussed just now in graphical illustration. On the right-hand side, I actually put down certain further discussion called the sovereignty and sovereign rights. So later on, I'll talk about this one. And the transit. So people who travel through all these different ocean zones, transit or called or compared to innocent passage. And also the last part that I want to discuss will be what happened to those countries who doesn't have a coastline, they are landlocked country or some country who are considered disadvantaged states. So all these I will explain in subsequent slides after this. Now, after I have introduced all the different zoning of the ocean, now overall, the overlay of the rights of countries, the one that own the sea or the one that actually can use the sea, are clearly defined in the United Nations UNCLOS as sovereignty, meaning you have a total control, and sovereign rights, meaning the user right. So there are two types of rights uh, overlaying on all those zones that I mentioned in my in the early part of this video. Now, so what is the difference between sovereignty and sovereign rights? Now, the reason why this is required is to ensure there is no conflict between countries who wanted to derive economic benefit from the ocean. So this is the most important distinction in the law of the sea, especially when uh, to ensure that we don't have a lot of conflicts among states, country. Now, to put it simply, sovereignty is total ownership, while sovereign rights are specific user right. So as you can see, anything from the baseline all the way out 24 nautical miles, these are considered sovereignty rights. So it belongs to the country. And this country has the power to make laws, police that area, and manage all the airspace and control the seabed, with the exception of innocent passage, meaning that the only catch is that in this water, the country must allow innocent passage to foreign ships, just like we discussed before. Other than that, the country is the boss of this part of the ocean and they can govern over the air, the water, and the seabed. So the sovereign rights actually apply only to the exclusive economic zone of up to 200 nautical miles. Okay, so like I mentioned just now, in this zone, the country that own this zone can do living resources fishing. They can do non-living resources such as looking for oil and gas, and they can also do energy production. But it does not cover something that it does not provide the fact that the country own the water itself or the airspace above the exclusive economic zone. The country only have the right to benefit from this zone, but they don't have the sovereign right to own the water and the airspace above. Foreign nations still have the freedom of navigation and overflight, and the country can't stop a foreign ship from sailing through the exclusive economic zone, but the country can stop them from dropping a fishing net. Now, why does this matter? Why there is a need to have sovereignty right over the ocean up to 24 nautical mile and sovereign right for on the exclusive economic zone? Now, this distinction is to prevent conflict. Now, if a state have full sovereignty all the way out to 200 nautical miles, then the world ocean would be a very difficult place of operation and it will result in many conflicts. And if that's the case, a lot of countries will need permission just to fly a plane or sail a cargo ship over the exclusive economic zone. So by using sovereign rights on the exclusive economic zone, UNCLOS allows country to get or to derive benefit from their coastal resources without clogging the global arteries of trade and travel. Now, the next slide, I actually produce another slide to show you what are the activities that a country's sovereignty right or sovereign right that can be applied on the exclusive economic zone. So you can see that some of these activities are actually allowed, and I actually put down there for a clearer presentation. And the next slide, I actually just do a recap, or I do some further illustration that when you come to anything beyond 224 nautical miles, this is called the global common heritage. That's the seabed or the area that belong to all mankind. So I actually do down here in this part of the sea area, you can do a lot of other activities, and of course there are still law to govern all these operation, but this part of the sea remain belong to all the countries, and all the countries have full commercial right or any rights to make use of the high sea. Now, after we talk about the sovereignty and sovereign rights, the next two slides I will focus on what are transit passage and innocent passage. Now, these are very two distinct legal frameworks under the United Nations Convention on the Law of the Sea, UNCLOS. A lot of people get confused here. So, the transit passage is actually the standing order or the standard for international straits when two overlapping exclusive economic zone of two countries overlap. So there are certain rules that still can govern the usage of this sea water or this ocean area. So the rules that govern this is fall under transit passage. Now, the other one called the innocent passage is more restrictive uh, regulation that apply to a state territorial sea, meaning the sea that is 12 nautical mile away from their baseline. So now you can see that within UNCLOS there is a part called transit passage that cover more than 24 nautical mile outside of the country in case this part of the exclusive economic zone overlap between two countries. Now, we're going to discuss now more detail about transit passage. Now, transit passage, as mentioned, is more liberal regime than the innocent passage. It was a critical compromise during the UNCLOS negotiations to ensure that the expansion of territorial sea to 12 nautical miles wouldn't close off narrow strategic waterways like the Straits of Malacca or the Strait of Hormuz in this Iran war. So let me explain transit passage in more detail. Now, transit passage applies to straits used for international navigation between one part of the high sea. That means one part is, for example, exclusive economic zone, and the other part is belong to another country, which is a territorial zone. So when this happen, does it mean that all the ship aircraft cannot go through these straits, this part, the narrow straits of the ocean? The answer is no. Under UNCLOS transit passage, now all ships and aircraft, including merchant vessels, warship, and military aircraft, are allowed to go through or pass through this type of narrow straits. And unlike innocent passage, transit passage includes the rights of aircraft to fly over the strait as well. Not only the ship and aircraft are allowed to fly over. How about submarines? Submarines are permitted to transit in this sort of a narrow straits submerged because when submarine is underwater, this is considered their normal mode of operation. But if they are under innocent passage, that means within 12 nautical mile of a country, they must surface and show their flag. So even those all these rights under the transit passage are given to the ships and the aircraft that make full use of these narrow straits, they also have some duty. So when exercising the rights to pass through these straits, vessel and aircraft must follow the following strict rules. Number one, it has to be continuous and as expeditious. And number two, there must be no threat of force. Number three, they must be operating under a normal mode, meaning they must refrain from activities other than those incident to normal modes of transit, such as no weapon practice, no launching of aircraft, no research surveying without proper authorization. And the last one is compliant. Those vessel and aircraft that make use of the straits of passage or navigation, they must follow international regulation for safety at sea and pollution prevention. Now, what are the rights and restriction of the bordering countries along this side of strait of navigation, the narrow strait within an ocean? So, states bordering the strait have sovereignty, but it is limited by the following. That means no, number one, no suspension. Countries along these straits of passage cannot suspend or hamper transit passage for any reason, even for security or military exercise. That means you cannot say that, oh, I'm conducting military exercise. You are not allowed to go through these straits. That's number one. Number two, it has to be non-discriminatory. Now, any laws or regulation passed by the bordering states or the country along these straits regarding fishing, pollution, or traffic must not discriminate against foreign ship, meaning they cannot use this as an excuse to actually stop any foreign ship to go through these narrow streets of the ocean. And the last one, no toll. Straits cannot charge ships for mere rights of passage. So this is like what mentioned. No one is allowed to charge any toll when other ships pass through all these straits of the ocean. Now, the next slide I have prepared and to show you all what is called innocent passage. Now, innocent passage means that remember we mentioned about the territorial sea and the contiguous sea, meaning up to 24 nautical miles from the baseline. Can any vessel or any planes fly over all this area? The answer is yes. If any passage or any activity fly over this area of the sea, they still have the right called the innocent passage. Now, passage is considered innocent as long as it is not prejudicious to the peace, good order, or security of the coastal state, meaning the country that own the 24 nautical mile out from the baseline. So any vessel will that pass through this zone will lose its innocent status if it engages in any of the following while in the territorial sea. Okay, so when you pass through the first 12 nautical mile or the next 12 nautical mile of the sea, you are considered innocent. uh, these are called innocent passage, meaning you are allowed to do so. But if you do the following activities, then you are not allowed to call yourself innocent passage because you are infringing on the sovereignty rights of the coastal country. Now, what are the activities that you are not allowed to do? Number one, military activities. Number two, intelligence. For example, you collect information, or you can't do propaganda. You cannot do extraction of resources, you cannot harm the environment, or you cannot interfere in the communication system of the coastal country. For example, you send a ship with all the electrical equipment so near to the baseline so that to interrupt the communication of the country. So these are you can't do. So under UNCLOS, there are also other rules to apply on vessels under innocent passage, meaning that you can sail through this area of the sea, but you must follow the following rules. So the first number rule is contentious and expeditious, meaning that you must move through this water without stopping or anchoring, except for incidental needs lah. For example, if there's accident or if there's any navigating safety. Now, for submarines, unlike the transit passage, submarine that go through this surface within the 24 nautical mile must surface and show their flag, the flag of the country. Um, Now, there's no right for the aircraft that can fly through this. So for innocent passage is not applicable to aircraft, and there's no right or overflight under innocent passage. Aircraft must stay in international airspace unless they have explicit permission. So when come to innocent passage, what are the rights given to the coastal state or the country that own the territory ocean? Now the coastal state has much control under innocent passage as compared to transit passage. Now, if the vessel is going through innocent passage, uh, a coastal country in the territory water can actually temporarily suspend innocent passage in a specific areas of its territorial sea if the suspension is essential for the protection of its own security, for example, for weapon exercise. But this is under the condition that all this suspension must be published and it must be non-discriminating. Number two, those states that dictate over this territorial sea, they can actually dictate the sea lanes and traffic separation scheme, and foreign ships are required to follow. So just like the Iran case, even though it's within their territory sea, they still must come up with the specific lane that international vessel can go through. So for this, we actually conclude the discussion on transit passage and innocent passage. Now we come to the last part of this video because I think to make this video complete, we have to talk about what about landlocked nation, country that don't have a coastline, don't have a baseline to start from. What happened to this country like Laos, Bolivia, Mongolia? This country do not have the coastline or the baseline. Now, landlocked nations, states with no sea coast actually face a unique geographical disadvantages. Now, to address this, the UNCLOS actually grants them specific rights to ensure they aren't blocked out of the global economy and the resources of the ocean. Now, the most fundamental right is the right of access. So, because a landlocked state cannot reach the ocean without crossing another country, so UNCLOS provides that number one, freedom of transit. Landlocked states have the right of transit through the territory of a transit state, the neighboring coastal country, by all means of transport. Number two, non discriminatory taxes. Transit states cannot impose custom duties, taxes, or other charges on the goods in transit, except for charges levied for specific services rendered, like port handling or road maintenance. Number three, equal treatment in ports. Ship flying the flag of a landlocked state must enjoy the same treatment in seaports as those of the coastal state or any other maritime nation. Not only they have the right to access to the sea, landlocked country also have the rights to living resources, such as fishing. Now, landlocked states have a right to participate on an equitable basis in the exploration of an appropriate part of the surplus of the living resources, meaning fishing, within the exclusive economic zone of a coastal states in the same area or same region. Now, what do we mean by surplus of the living resources? Now, this right only applies if the coastal state does not have the capacity to harvest the entire allowable catch itself. So, in the exclusive economic zone, a landlocked country behind the coastal country can actually send their vessel to do fishing if the coastal country does not have the full capacity to harvest the entire resources. These specific details of the access are usually settled, but these specific details of the access are usually settled through bilateral agreement between the landlocked state and its neighbors. But what happened to the common heritage of mankind? This means any part of the ocean that's beyond the exclusive economic zone, or they call the deep seabed area. Now, beyond this, landlocked country has landlocked country have equal rights here for resource sharing. They are entitled to share in the financial and other economic benefits derived from activities in this part of the sea, such as deep sea mining. And they also have representation rights. They have the rights to be represented in the International Seabed Authority, the body that organizes and control activities in the deep sea bed. And last but not least, they also landlocked country also have the right to conduct marine scientific research in the open sea or the sea that doesn't belong or the sea that belongs to all mankind. Okay, now we have come to the end of this video. Again, the law of the sea is a very complicated topic. It would take many days to discuss this topic, but what I've done uh, in this video is to give you the gist, those important knowledge that will help you in your career or in your business decision. So hopefully you like the content of this video and do subscribe to my video or circulate my video to your friends so that they can also enjoy this video. Thank you very much. See you next video. Bye bye.